Hi, my name is Goldman. I'm an attorney with Goldman Associates. Today I'd like to talk about custody, but custody involving unmarried people, folks that have never been married, and throwing that into the mix, what if we have a special needs child? Well, first things first, there's a presumption in the law that if couples are married, that they share, at least to some degree, equally in the raising of the child and the custody of the child, and that presumption attaches to married relationships. If we have a child who's the product of a non-marital union, no such presumption exists. So if the father in that scenario is on the birth certificate and the relationship falls apart and then he wants to perfect some of his rights, he's going to have to go to court. He's going to have to go to court to get those rights, and then perhaps he too can share in the custody of the child. Now, what happens if the child is special needs? Well, that becomes a particularly interesting item to throw into the mix, because sometimes, depending on what those needs are, one parent may be better suited to take care of the special needs of that child than the other. So even though we may have a standard custody situation where, let's say, we have a non-marital union, there's a child born, there's a presumption that the mother has the custody, but in this particular case, it's the father who is more able to provide the appropriate therapy that's necessary to provide the appropriate environment for the child. So the court may very well find that in that specific circumstance, it's in the best interest of the child, given the special needs, to go to the father. So there are all sorts of things that go into that kind of analysis, but you need to know that the special needs of a child must be taken into account by the court when it determines appropriate custody arrangements. If you have any questions about that, of course, reach out to us and we'll be glad to help you out. If you have found this helpful, please like and share.